Author's discussion of regulation and the court's involvement is pretty comprehensive. I will make a few comments as I go through and try to point out things that are inconsistent with my experience that appear in the theory the author reports. I find the author's treatment of the goals of regulation to be substantially correct. However, there are issues where regulation and the regulators become a means to their own ends. In other words, the regulation, the original purpose of it, and the outcomes have been achieved, but the system continues to go on because of the interests of the individuals in the government and in the special interest groups and in the congressional committees of jurisdiction who do not wish to relinquish the authority and power that the regulation provides for them. This makes it doing away with these things very, very difficult. The history of the Interstate Commerce Commission is one very good example. The author makes the point that federal regulators are more expert in their particular fields. In my own experience, I find that many of the regulators outside of the very senior levels are really more expert at processing paperwork than doing anything else. And the idea that the entire organization is full of these highly competent people is really not the case. These often turn up as unnecessary burdens because it's what I call the theory of the yellow copy. Somebody's job depends on the yellow copy, so we keep a three-part form, so we have a yellow copy. Even though the need for that has long since been obfuscated because we now have all the forms online. I ran into exactly that problem while I was at Commerce. Economic regulation actually began long before the 1887 or even the states or even the United States because, at least in my opinion, government forms the environment, if you will, the legal and statutory environment. It creates the money that's used in transactions. It forms the environment in which the economic system exists. You cannot imagine a market in which there is no money, no regulation, etc. If you consider, for instance, my own situation, I do not live any longer in Oregon. However, the governments of Oregon and Washington and the United States have created this infrastructure, this environment, in which the people who have lived in those properties, in some cases for 15 years, cannot just say, hey, this is mine now. I can control my property management agent and their actions, and they have a system that allows me to transfer the money. They even created the money, for that matter. And all of those things are the creation of government that allows me to do these things. That is something I think that the author misses just a little bit. Key problem here is this so-called capture. You can look through the history of, for instance, the Securities Exchange Commission, and about every 10 years, there's a major scandal, and then there's books written that end with now all the problems were fixed because there'll be these reforms, and then the same thing happens again. And the reason is very simple. The senior people who are really making the decisions, and I'm talking about the senior civil service people, are essentially trying out or whatever for jobs with Wall Street and the stock exchanges and that sort of thing, and they don't want to anger these people. And so there's a lot of attenuation that goes on between what actually should be enforced and the enforcement. It's not until somebody like a Bernie Madoff starts robbing from rich people that the problems come home to roost. So I think you need to understand that the capture thing is a very, very big problem because the senior policy implementers, the senior civil service people, are very susceptible to this capture for jobs after the so-called revolving door, jobs after their federal retirement that earn them a lot of money. It's a pretty good job with social regulation, so I won't really talk about that. However, the author makes what I believe is a fairly common error in characterizing externalities in a negative way. Externalities can be positive or negative. They are simply things that happen as a result of an action I take that affect you or somebody not in the food chain. So it could be a positive thing. Doesn't necessarily have to be negative. However, it is the negative externalities, such as my smoke interfering with you breathing, that causes the government to intervene with negative externalities. Notice that the definition of negative externalities changes over time. If you look at the movies from the 50s, everybody is smoking. If you look at the movies today, it's generally only the evil people who are smoking, and you can't smoke in restaurants and bars, et cetera, where it used to be very, very common. So what is a negative externality? The definition of that is normative, and those norms change over time. It's very important to realize that. In the general case, state and local regulation is okay as long as it meets minimum federal standards. In the case of local governments, it's really a different situation because they are creatures of the state under Dillon's rule. But the idea that they are doing these things autonomously is not really correct. They have to do them within the boundaries. In other words, no state can unpass the civil rights legislation or do anything like that. They can enforce it more strictly or do something that is more than, but less than is much more difficult. This is a very interesting observation and generally is true. Economic regulation tend to be very general, and social tend to be much more specific. I believe this arises from the legislative histories, which you can look at, where the economic regulation is broad and general because the problems are broad and general. The social are attempting to address specific problems that have come up, and you can almost look at the laws and see them being provisions being added in by special interests who have particular issues that they'd like included in a specific social mandate. I have to take issue with the assumption that most agency staff are experts. In many cases, you find, in my experience, you find people who were probably experts at the time they entered the agency, but have not upgraded their skills to current practices. And that becomes problematic when they're trying to apply their expertise to regulation. I'm not saying that all of them are incompetent. I'm simply saying that in many cases, the assumption that the staff is generally competent is inaccurate. Cost-benefit analysis is a whole other bucket of bolts. I actually don't cover that and left it out of the public finance and policy analysis curriculum, primarily because of the mathematical requirements in an open admissions program. We don't have a GRE or anything that sets mathematical levels, and so it becomes problematic whether people can engage the process. If anyone's interested, when we get into that, I'd be happy to put up some of the materials I have on cost-benefit analysis. It's actually pretty interesting, and I will say that it is driving forward a lot of what goes on currently. Risk assessment is another area that changes with the normative conditions of society. In other words, it changes as we go along. The example they give about Sandy is certainly one example. The question of perception is really what drives all the regulatory decisions in the final analysis. Risk assessment also involves risk assumption. In other words, if you are a risk-averse person, then why would you build a home on the water in an area where you know there are going to be hurricanes? Well, the idea that the government may insure you against those losses could be causing what's called an adverse selection effect. In other words, you might be doing this because you believe the government will bail you out. The other difficulty is that people don't understand statistics. So, for instance, if you build in a 100-year floodplain and you figure, well, there was a flood last year, it ain't going to happen again for 100 years, I'll be dead by then, that is not what the 100-year floodplain means. Right? It is a technical, statistical value, but it is not something that most people understand. And so when they get flooded out 2 or 3 times in a 50 or 100-year floodplain, I heard all kinds of people say, well, how can this happen? They said it was a 50-year floodplain, and it's been, 3 times in 5 years. And it all involves the fact that they don't understand the statistical values. And so when people talk about this, they really are not talking the same language. I've been involved in administrative rulemaking, and the process, at least at the federal level, is fairly simple, although it's time-consuming. You get a law, you get a statute, you get some reason to proceed forward in regulation, and you draft a regulation and you publish it in the Federal Register, and generally speaking, there's a 30-day response period. You get people, interested individuals, etc., commenting on it. You get all kinds of lobbying from congressional committees, etc., and then you publish the final regulation, and you're done. Fairly simple, fairly straightforward. I have never been through adjudication, so I won't speak about that, but the administrative rulemaking process is fairly straightforward. It just involves a lot of politics. Administrative rulemaking is, as our author says, pretty much a simplified process. Although the idea that Congress just delegates power to administrators is not really accurate in practice. In practice, when you publish things in the Federal Register, and even before you publish in the Federal Register, you're crazy if you don't check with committees of jurisdiction and other interested parties. So the idea that you're publishing these things after reading what Congress says and that's it, and that you have a delegated power to do this is really not accurate in practice. Adjudication of rules was always handled by the Chief Counsel's office, and I never had much to do with it. However, indeed, if someone feels wronged by the rule that you finally publish, they can indeed take you to administrative hearings, and the ALJs make some sort of decision, and you're off to the races. And they can either force you to act or not act based on the rule and the judge's decision. However, these things are usually very protracted. By the time you get done with all the appeals and everything, everybody's retired. I find the author's assertion that court decisions are inconsistent in this area to be humorous. Court decisions are inconsistent in all areas because they're made by lawyers and juries that really have a whole emotional content that they really don't think through the issues and what are the actual damages in the first case. And in the second case, how you value some sort of damage to a person's health, etc., is very, very problematic. But the courts are not really a very useful organization to deal with this. I mean, they do have procedures and they have the veil of legitimacy, but they're really not very effective. While government agencies can, under certain circumstances, waive their sovereign immunity and be sued over these various types of things, the typical or more typical way to get around it is simply have the legislature appropriate the money that otherwise would have been awarded. That's what happened in the case of Flint, Michigan. Originally, the state officials, DEQ, and even down to the local water folks, were charged with felonies and this and that. Of course, they all got off with very small misdemeanors, and there are all these long-term health care issues that came up. And what the Michigan legislature did in order to bypass all this is they just appropriated money, and they've given it to the people who otherwise would have been in a class action suit over the water quality issue. That's much more typical in terms of government actions because there's just no sense in fiddling around with the courts. I really can't speak very authoritatively on, lacking a modern legal education. I am not really able to understand how these rights to sue come up, and as our author points out, they've changed over time, so they're not static. And I think they probably have a great deal more to do with the normative standards of the society at the time than any sort of legal theories. I certainly would not characterize the courts as passive, although in the sense that the author uses the term, it may be accurate. They do require someone to sue. However, if you go back, for instance, to the Warren Court, they actively looked for plaintiffs. So the idea that this is all some kind of process that goes on run by neutral people who are not part of the society is nonsense. If that were true, then the members of the Supreme Court would not matter, and yet those are hard-fought battles. The courts indeed do tend to make law, and they change it as they go along. And again, this is despite the formal facade of the courts and procedural stare decisis and all this other nonsense. It really is nothing more, nothing less than a socially interactive sounding board. What is right today could be wrong tomorrow, and that is just the way that statutes are interpreted. Statutes start out as one thing and then they become another. It really is not as neutral and precedent-driven process as many would like to pretend. Trump's administration is a good example of this. Certainly, his obvious intent to try to control the Federal Reserve with respect to interest rates is perhaps the most immediate example we can think of. He believes that the low interest rates are driving forward the economy and, not coincidentally, his re-election chances. And so he lobbies, if you will, castigates in some cases, the Federal Reserve, who are technically independent of him and the administration with respect to their interest rate decisions. This is not unusual. In one way or another, presidents have always tried to influence some of these independent regulators and quasi-independent corporations. I can certainly agree with the conclusion that the purpose of government is to regulate the behavior of those who live within the state. Your rights are a gift of the state. They change as you move from state to state, i.e. if you move across the border to Canada, you gain some rights and lose some rights that you have if you stay in the United States. The idea of protecting others from harm is certainly part of the equation, but there are also other priorities.